我請同事們返埋位啦，好嘛？差唔多夠鐘開我哋嘅聯席會議。
Members, please take your seat. It's about time for us to start the joint panel meeting.
OK 啦，你嚟啦。好，各位同事。
Members, it's time and we have a quorum. So I call to order the joint meeting of the panel on security and panel on administration of justice and legal services. The administration officials are now joining us. Item 1 on the agenda, election of chairman. Mr. Martin Liao, chairman of the panel on administration of justice and legal services, agrees to let me chair the meeting. Is there any objection? If not, then I will continue to chair the meeting. As you know, this morning the chief executive launched the public consultation on Basic Law Article 23 legislation. I ask for members' understanding in calling this joint meeting at such short notice. In a moment, I'm going to invite officials from the government to take us through the paper. Probably it will take a bit of time because it's the first time that there is this formal briefing on the consultation, and it's also the first time for the public to learn about the details of the legislative exercise. And then I'll invite members to speak. You can press the request to speak button. Now I'll see how many members wish to speak. I believe there will be quite a number of them, and then I'll decide how much time to allow for each member. But please be concise in your questions so there is sufficient time for the administration to give a reply. Now I'm not going to introduce all the officials to you. Although Mr. Paul Lam, Secretary for Justice, Secretary for Security, Mr. Tang Ping-keung, and then Mr. Horace Jum, Deputy Secretary for Justice, and Mr. Patrick Lee, Permanent Secretary for Security. Secretary for Justice, are you going to say a few words first? Yes, please, Mr. Chairman. First of all, I'm grateful to the panel on security and the panel on administration of justice and legal services for agreeing to hold this joint meeting. I would like to thank all members present too. This gives us the opportunity to brief you the public consultation document on legislating for Article 23 that we launched the exercise this morning. There are 9 chapters and 3 annexes in the document. And there is also a leaflet to help people to give their views. I will first talk about the principles in chapters 1 and 2, and then Secretary for Security will brief you on the proposals. Now, there are 4 musts for us to talk about the legislative principles. First, we must have regard to the actual situation in Hong Kong, and we must have regard to make reference to experiences overseas. In accordance with international convention and practices, safeguarding national security is the integral right of a country. This is to ensure territorial integrity and the well-being of the people. Security is always one of the first considerations, and all countries will treat safeguarding national security as one of the top priorities. That's why every country will have legislation on safeguarding nationality. Usually there are more than one pieces of legislation. For example, in Annex you see US has at least 21 pieces, UK 14 pieces, Australia not 4 pieces, Canada 9 pieces, and New Zealand 2 pieces, and Singapore 6 pieces of legislation relating to national security. The common thread is that they will take necessary measures to safeguard national security, and also they will keep reviewing and maybe adding more legislation to respond to the latest forms of national security risks. They will make sure too they could respond swiftly to unexpected threats and risks. And so, in other words, the relevant legislation must be forward-looking and must be effective. Now, learning from the experience of other countries is important, but at the same time, we need to have regard to our unique situation and formulate a piece of legislation that meets the needs of Hong Kong in safeguarding national security. And secondly, we need to fulfill our constitutional duty to legislate for Article 23 as soon as possible. Now, under One Country, Two Systems, in accordance with Article 23 of the Basic Law, Hong Kong is given the power to enact legislation on its own. The wordings in Article 23 is that we shall enact laws on our own. So this is our constitutional duty, but then we've been returned to the motherland for 26 years. We still have not fulfilled this constitutional duty. In Article 23, there are seven types of acts for safeguarding national security, but then the national security law only covers 2 of those and doesn't cover the other 5. Now, Article 3 of the May 28th decision and also Article 7 of the National Security Law state clearly that we must enact as soon as possible legislation for safeguarding national security. And also, we need to fully implement the May 28th decision and the requirements of the national security law. Now, one of the legislative intention for legislating 23 is to ensure the implementation of One Country, Two Systems, ensure territorial integrity, and ensure long-term stability and prosperity of Hong Kong. So it's in line is to promote the development interest of the country, and then we must fully and accurately fulfill our constitutional duty in that respect. Now, Article 3 of the May 28th decision and also Article 3 of the National Security Law state that Hong Kong has the constitutional duty to effectively prevent, suppress, and impose punishment for any act or activity endangering national security. And also that we need to have the relevant institution and mechanisms in place for safeguarding national security. That's Article 4 of the May 28th decision. And also in accordance with Article 62 of the National Security, the national security law shall prevail where provisions of the local laws of the Hong Kong Special Administrative Region are inconsistent with this law. For this reason, the legislative exercise for Article 23 must also fully implement the requirements in the May 28th decision and the national security law. So there has to be there must be we must achieve convergence, compatibility, and complementarity with the national security law. And then we need to enhance the relevant legislation, including the law enforcement and court trial procedures. And also, we have to have regard to international standards that apply to Hong Kong in safeguarding human rights and freedoms. So Article 4 of the National Security states that we must respect and protect and safeguard human rights and all the relevant provisions in the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights that apply to Hong Kong shall, in accordance with these covenants, we must protect the human rights of the people of Hong Kong. And then we have to go by the international standards of these international covenants in protecting human rights and freedoms. And so we will certainly do so in legislating for Article 23. But at the same time, we must not forget that in accordance with these international standards for certain rights and freedoms such as the rights of assembly and speech, they are not absolute. There must be necessary limitations for the purpose of safeguarding national security. So Article 2 of the National Security Law states that we must not go against Article 1 and 11 of the and then 12 of the Basic Law, because we are under the People's Republic of China. And then Article 5 of the National Security Law also state that we must adhere to the law in imposing punishment. So that means the offences must be stated clearly. So we will have clear definition on the elements for various offences. They will also allow certain exclusions and defences. And we will have regard to the usual criminal law principles. We must prove the mens rea. There is someone deliberately breaks the law. So we don't need to worry that we will unwittingly be caught by the law. The legislative proposal will not affect the day-to-day activities, trade activities and interactions with other countries. Now, we must bear in mind that the Basic Law, the Bill of Rights Ordinance ensure that people are entitled to fair trial in Hong Kong. And before anyone is convicted by the judicial authority organ, the person is presumed innocent. So the person has the right to defend himself and so on. And if someone is prosecuted in future in accordance with this law, then the court will continue to exercise independent judicial powers in conducting the trial. The offense was proved beyond doubt before a person can be convicted. So those are the basic legislative principles. Now I will invite Secretary for Security to brief you on the proposals themselves, and then later on we will be happy to answer questions from members. Thank you.
Thank you. Legislation for Article 23 of the Basic Law is not just a constitutional duty, there is practical need. Hong Kong has gone through national security threats. In 2019, we had the Hong Kong version of a color revolution that brought an intolerable pain to Hong Kong. We saw serious violence, law and order worsened, rioters broke the law trying to achieve Hong Kong independence. They set fire, vandalized property, and beat up dissidents and damaged property that led to insufferable consequences for the community. The international scene changes rapidly. National security threats exist every day. There are hostile forces watching us in a menacing way. Foreign intelligence bodies openly say they will put more resources into act against our country. Our own country has exposed the despicable acts of those hostile forces. Given the day-to-day national security threats, we must legislate to cope with the continuing national security risks. So as a principle, there is a practical need for us to legislate for Basic Law Article 23 promptly. We need to improve the legal system for national security. There's a strong community consensus. The SCL government needs to get through the legislation as soon as we can to plug this loophole in national security. The sooner we get through the legislation, the sooner we minimize the national security risks. We have roughly a month for consultation. We have considered the factors and we find this period appropriate. It's 26 years since Hong Kong has been returned to Chinese rule. We have yet to fulfill this constitutional duty. We must do it quickly. So the government has released the consultation document. That's step one in the legislative work. This is a long overdue task. We need to get this right so that we can then focus on the economy and improve people's lives. At the press conference this morning, I briefly discussed the consultation document. I will now come to some points of interest to electoral members as I go through the proposal. There are 9 chapters in the consultation document. Chapters 1 to 2 are about the constitutional duty to safeguard national security, the national security risks, and the necessity for the legislation. We also explain the legislative principles, the factors we consider, and the research methodology. Those parts have been covered by the Secretary for Justice. Chapters 3 to 7, the offenses, they cover 5 major types of offenses that endanger national security. Most of them are about improving existing laws. So we have regard to Hong Kong's actual conditions and also propose new offenses to effectively prevent, suppress, and impose punishment for acts and activities endangering national security. So these 5 chapters, they are Chapter 3 on treason and related offenses. The proposal is to improve Parts 1 and 2 under the Crimes Ordinance and also common law offenses. Treason will be under the new law. This means removing outdated parts and also covering treasonable offenses. People seeking to endanger national security may receive drills from foreign forces. We need to cover that. Chapter 4. Sedition insurrection, mutiny, disaffection. Our proposal is to improve Part 2 of the Crimes Ordinance so that we cover. This means adjusting the target of incitement. Police officers, members of the government flying service and auxiliary police, we will cover them, and we will expand the scope to cover also people involved in policy making, maintaining public order, those in the judiciary, and also public officers with statutory powers of investigation. We also recommend learning from overseas laws to bring in the offense of insurrection, to deal with insurrection that seeks to undermine law and order and those seeking to instigate armed revolts. Chapter 5. Theft of state secrets and espionage. This is a matter of interest to members. On protecting state secrets, we need a clear definition of state secrets so that public officers, government contractors, and the public can tell what counts as state secrets. The definition is something where we need to look at our national laws on state secrets. So there will be a detailed definition of state secrets. Paragraph 5.8 in the consultation document sets out this point in detail. Disclosure without lawful authority, likely to endanger national security, that counts as disclosing state secrets. To prove this offense, we also have to prove the mens rea. Disclosure of state secrets is part of the laws in places like the US and Canada. In paragraph 5.8 of the consultation document, we set out these points clearly. Whereas in overseas laws, they don't spell those points out clearly. There's greater ambiguity in overseas laws, but we spell things out clearly here. Now, we also set out overseas laws and the situations applicable to Hong Kong. So we propose improving the Official Secrets Ordinance. So that state secrets and official secrets in Hong Kong can be protected from theft and unlawful disclosure. Apart from unlawful disclosure, we propose a new offense, unlawful access to state secret and also unlawful possession of state secrets. On this point, some argue when major public interest is involved, some people wonder there should be immunity. This is where we welcome comments. And then we will consider those comments. On espionage, we recommend improving the offenses about spying under the Official Secrets Ordinance. Foreign forces may try to get their agents in Hong Kong to spread false information or misleading information to interfere in Hong Kong's affairs. So we recommend learning from overseas laws to ban the taking part in or receiving of benefit from outside foreign intelligence bodies. Chapter 6. Sabotage to endanger national security. This covers sabotage that also covers those done on a computer or electronic system. So we recommend creating this new offense, damaging or impairing public infrastructure, or endangering national security on a computer through an electronic system without lawful authority. These acts undermine national security, so they need to be banned. So on top of existing offenses such as damaging property or access to a computer with dishonest intent, we propose creating this new offense that specifically targets acts to endanger national security to cope with the risk and strengthen the deterrence. and also clamp down on such acts done on the computer or electronic systems. Chapter 7 on external interference and organizations engaging in activities endangering national security. On external interference, we propose banning anyone from working with foreign forces, from using tactics such as deception, intimidation, to sway policy-making and delivery in the Hong Kong SAR or the central government, or attempts to influence the performance of functions at the Legislative Council in the judiciary, or attempts to interfere in Hong Kong's elections. This is about preventing foreign forces from improperly affecting the affairs in Hong Kong and in our country. On regulating organizations, other countries have registration schemes for foreign bodies. After due consideration, we will not bring in such a registration scheme in Hong Kong. Under our society's ordinance, we already have a system that is familiar, that people are familiar with. So we propose keeping such provisions under the society's ordinance. Under the society's ordinance, the provisions apply to just societies, but not to the bodies in the schedule, such as cooperative societies and owners and some corporations or Chinese temples bodies. This is not ideal. This means those seeking to undermine national security can register their bodies in other forms to circumvent the society's ordinance. To better guard against such risks, that is, to cope with the risks from bodies exempt from the society's ordinance, we propose expanding the scope of the society's ordinance to cover those bodies. We're simply expanding the scope without changing the provisions under this ordinance. Chapter 8. For certain offences, we propose creating proportionate extraterritorial effect. We have considered international law and international practices. We have also considered the national security law's extraterritorial effect, our existing laws and existing practice in other countries. Chapter 9. This is about addressing shortcomings, inadequacies from the implementation of the NSL. In complex cases, the police force needs more time to collect the evidence and decide whether to press charges. This is where we welcome comments to improve the legal system and enforcement mechanisms for safeguarding national security. I want to highlight 3 points. First, the government has considered relevant laws overseas, applicable laws in Hong Kong, and Hong Kong's actual conditions before we come up with the proposal. In the legislative work, we have looked at and learned from overseas laws as appropriate, but this does not mean wholesale replication of overseas laws in Hong Kong. Second, we will take a targeted approach in addressing national security offenses. We will set out the elements and penalties clearly. The prosecution has to prove beyond reasonable doubt both the criminal act and the criminal intent before the defendant is found guilty by the court. This means law-abiding citizens don't have to worry about inadvertent breaches of the law. Third, the legislation will not affect the exchanges among people and business groups. We are an international city. We have close ties with the outside world. Normal exchanges are protected by the Basic Law and Hong Kong's local laws. Legislation for Basic Law Article 23 is meant to prevent, suppress, and impose punishment, acts, and activities endangering national security. And there's a huge distinction between normal exchanges and acts that endanger national security. National security is key to prosperity and people's well-being. So we would like to consult the public on this legislative proposal, and we welcome comments. Thank you. Thank you, Secretary. I also thank Mr. Paul Lam for his opening remarks. I now open the floor for members. 22 members are lining up to speak. We want to allow as many members to speak as possible, so 3 minutes for each member. Questions and answers inclusive. Please be brief. Let's start with Dr. Tik Chi Yun, Mr. Jesse Shang, Dr. Lo Wai Kwok, Mr. Tang Fei, Mr. Holden Chow. Dr. Tik Chi Yun, 3 minutes. Thank you, Chairman. Thank you. I got to be the first one to speak. We have a 1-month consultation. The government has told us about the basics of the consultation and the consultation. The public asked me what would happen in this month. Officials have stated clearly the need to explain the legislation clearly to allay public concerns. So what will be done in this month? How will this month be used to explain the legislative work well? What are the specific arrangements the government has in mind? Secretary for Justice. As stated in the consultation document, we welcome comments through a variety of means, fax, email, doesn't matter. We will be proactive in our approach. We will set up seminars with different sectors and groups. My colleagues and I will listen to views from different sectors. We will listen to what questions people have and then respond in a timely way. We will be proactive in our effort. So do you have a timetable in the works? But the goal is clear. We will be proactive in explaining the work. Now on the practicalities. We will meet with professional groups. We will also talk to youth groups, the media. We will hold town halls. We will also go to radio stations, TV stations. There will be press interviews. We will use every opportunity available to explain the local legislation. Dr. Tik, any follow-up? The wider the scope you go in the consultation, the better. The people in the welfare sector, in the grassroots, have many things in mind. There are people with disabilities, seniors, carers. They don't want an extra source of stress. They are also social workers. They are part of the community. Would there be implications of the national security legislation for them? So please talk to the social welfare sector too. Secretary, please note that. Mr. Jesse Shang. Thank you. I support legislation for Basic Law Article 23. Now this legislation is long overdue. Back in the 1980s, the Basic Law was drafted. We knew back then we needed to legislate for this. 1990, the MPC endorsed the Basic Law. 1997, Hong Kong returned to Chinese rule. It's 26 years since 1997. In 2019, we had the black-led violence. There is community support for safeguarding national security. I see quite a bit of new content in the proposal. There's a part on banning acts that endanger national security done on a computer or electronic systems. Can we have more details on this point? Last Thursday, the chief executive was here for a question and answer session. There is artificial intelligence now. There are hidden risks with AI. The chief executive brought up the point about technology neutral. So how does this point interact with the proposal about crimes done on a computer or electronic system? Secretary for Security.
Well, our legislation will be forward-looking. For activities in relation to national security, we'll see what form of media we'll use. maybe in the past is some physical sabotage, but now maybe people use computers. That's why we have to regulate the use of computers too. At the same time, we are including electronic systems because there may be new developments in technology. Maybe computers will become something outdated. So it's about the principle. That is, whatever tools or means people use, they will be covered. And that's what we are trying to do by including such wordings. Mr. Shang, well, a quick follow-up. This is a new piece of legislation. Is rather complicated too. So please make sure there is sufficient time in February to consult the information technology sector, because the feedback I get is that they are worried that the people are just taking advantage of the technical staff, and maybe they don't know their real intent. So please do consult the sector proactively. Dr. Lo Wai Kwok, thank you. Well, if the country is stable, people enjoy a sense of security. If the country is not safe, then people cannot enjoy life and a secure living and work well. In 2019, we see arsons, the MTL stations were damaged, and someone was torched even, leading to serious injury. At the time, life was really tough for us. Fortunately, on the 28th of May 2020, the NPC made an important decision, and then very soon the national security law was promulgated and implemented. And then we could see that since the promulgation of the national security law, we're seeing peace and stability coming back to us. Finally, we are able to enjoy normal lives again. But then the national security law does not cover all other acts that may endanger national security and the safety of and stability of Hong Kong. So that's why legislating for Article 23 is a must. In fact, is overdue. Of course, we need to do our best to listen to views. But then, legislating for Article didn't start just today. There was this painful experience before, and then finally we see the benefits after the national security law was promulgated. So that's enough endorsement of this exercise. As members of this council, of course, we need to work with the government to make sure the legislative exercise is done properly. But then for the consultation, how can it be done properly? I think we also have a duty here. Perhaps because we have our own channels to solicit views as well. So I hope members will all work on that. Now, just now, some member asked about the actual consultation exercise. Well, there's not enough time. We can't cover everything, but I'm sure there's plenty we can do in terms of consultation. So that's just a view. Please note that. Mr. Tang Fei, I have 3 questions. First of all, of course, I'm very much in support of legislating for Article 23, which dragged it out for so long. Now, the question is, how do we do promotion and publicity on consultation with the education sector? Now, if it's publicity and promotion, usually you wait till the enactment of legislation, but of course we can't wait till that late. Now, national security education is important part of basic law education and so on. So teachers want to know how we could incorporate the content of the law in the curriculum. And the second point, the Chief Executive said in the interactive session that there will be a refuting mechanism. That is, when we legislate for Article 23 and someone tries to smear the effort, then they will have a rebuttal team. So how does it actually work? And then thirdly, question, Chapter 7 refers to external interference. What is the difference between external and internal? Because during the 2019 Black Flag violence, I'm sure you all share this impression. Now, so-called external interferences may not come from Western countries, but from certain regions in China as well. You know which region I'm referring to. So does this external interference cover the parts of China too, where there's interference coming? Well, consultation with different sectors, that's definitely necessary. But then we have thousands of sectors in Hong Kong. Can we do a briefing session for each sector? Probably it's not possible. But then there are maybe we can have town hall meetings, as I mentioned earlier. Then maybe the social workers sector or the education sector, they are all welcome to come to these meetings, and so make sure that every sector can take part in the exercise. Now, on publicity and promotion, I agree. Now, we have to wait till the enactment of the legislation, and then we'll see what more we need to do on publicity and promotion. The rebuttal team, I actually had the team. Why is that someone proposed that? If people say you could just clarify the misunderstanding, there's no need to rebut views. Well, if it's misunderstanding, of course we can clarify, but then there are others who deliberately badmouth us or smear the campaign, and they release false information. Then we have to do rebuttals, and then we'll let the public see what they trying to say is actually false, and they deliberately don't want national security to be sound. And then external interference. Yes, there will be a definition in the law on what external means. That means places outside of the mainland China, Hong Kong, and Macau. Mr. Holden Chow. The DAB is fully in support of the legislative exercise for Article 23. I welcome the launch of the public consultation. I'm sure even members of the public are fully aware of the urgency and necessity for to legislate for Article 23. Now, in other countries, they have certain standards in safeguarding national security. For example, the UK passed a National Security Act last year, and then for foreign bodies, for every activity they engage in the UK, they need to register it. If they don't register, then it's a criminal offence, and the maximum penalty is 5 years of imprisonment. Now, in our consultation document, it said that we are not going to go that far. And then for individual foreign bodies, if they endanger national security, then their activities could be banned. So Hong Kong is an international city. For foreign groups, certainly will carry out certain activities in Hong Kong, and so that's why we see Hong Kong has done a good job in achieving the right balance. But then in UK, they are actually more stringent than us. So in a consultation exercise, I hope you will make reference to such examples and standards adopted in Western countries, so we can tell people even Western countries have highly overriding provisions, and they're very stringent too. And then we can tell people that our Article 23 legislation is certainly in line with international standards, and then we're not going against international convention or covenants. Well, I fully share your views. In Annex 2 to the consultation document, we have listed out relevant provisions in other countries. And so you're actually referring to paragraph 7.4 in the consultation paper, the registration system. So this is the experience overseas, but we are not just mechanically replicating their system. We have to consider the situation in Hong Kong. On the one hand, we need to fulfill this important duty of safeguarding national security. On the other hand, we need to give full regard to people's concerns, say, about human rights and freedoms, in particular freedom of assembly and so on. So we already have existing provisions that are good enough. We just need to make some adjustments. So the thinking is that we make reference to overseas experience, at the same time we consider the actual situation. There's a reason why we need to make reference to overseas experiences, because there are some countries who claim that they, and I'm sure they do actually, respect human rights and freedoms. So their legislation certainly must have achieved a good balance in protecting human rights and freedoms. That's why there's reference value. Professor Priscilla Leung, I'm glad that finally we're seeing this consultation document on legislating for Article 23. We've delayed work for over 20 years. And we keep saying that this is the constitutional duty of Hong Kong, but I must say that it's more than that. It is also an opportunity for Hong Kong. Because all around the world, legislating on national security is a matter for the central authorities. Local governments are not given the power to legislate, but Hong Kong and Macau are the only exceptions around the world because we have one country, two systems. So this is actually an exercise to safeguard one country, two systems too. So this is a much cherished opportunity for us to legislate for Article 23 as a local government. Now, in the process, as the Chief Executive, the Secretary for Justice and Secretary for Security said, the exercise also about updating some outdated provisions. And second point is about common law offences. Now, some of these offences will become statute law, and it's important because not everyone in the community is a lawyer. Now, lawyers may be able to see the principles in under the common law jurisdiction, but then in other places there is strict, stringent regulation in relation to national security. Now, actually, many people are happy to see that finally we'll be legislating for Article 23. I must say that there is a high level of consensus in the community. In 2019, on the 12th of November, I gave a lecture for 3 hours in the city university. There had to be 10 security officers, Gurkha security officers, outside the classroom to protect the dozen or so students and myself. So we couldn't even conduct classes normally. So this legislation will actually protect everyone, and it's also in line with international standards. Now, in other countries, when they have discussions about legislating for national security, they will say that they are not going against international standards on protecting human rights and freedoms. And then we state clearly, too, that we are going to go by the standards of the International Covenant on Civil and Political Rights. So we fully respect human rights and freedoms. And I agree that this law must remain organic. And then in 5.10, I agree that changing the definition of civil servants to public officers. And what would that cover? Contractors paid by the government. Professor Leung, your time is up. Perhaps there could be a response on another occasion. Ms. Maggie Chen. Thank you, Mr. Chairman. I'm all for the SAR government starting the legislative exercise for Article 23. Now, in the public consultation document, it stated clearly that since the reunification of Hong Kong SAR with the mainland, it's been 26 years, and then there are shortcomings and legal loopholes revealed from various incidents. So that's why there's a necessity and urgency in legislating for Article 23. Now, we can see that in the UK, the US, or other countries, they also have national security legislation. In fact, their legislation is far more stringent and extensive than ours. So now, as we legislate for Article 23, we are giving effect to national law. It is just a normal exercise. At the same time, we need to create a safe and facilitating environment for businesses and so on. This will enhance the confidence of overseas investors. In fact, since 2022, I've been advocating for the decolonization of our laws. Now, if we legislate for Article 23, it will benefit our development. It will create a good business environment. It's the best protection for the interests of the people of Hong Kong. My question is, this legislative exercise will deal with Cap 200 crimes ordinance, in particular in relation to the removal of the colonial elements. Will there be removal of colonial elements in other pieces of legislation as well? Thank you.
Secretary for Justice. There are outdated provisions from the colonial era. We remove the colonial elements. This is an ongoing effort. This does not apply just to those about national security. On drafting local legislation for Basic Law Article 23, we have noted, say in sections 9 and 10 of the Crimes Ordinance, the provisions need to be adapted. So where the provisions have to do with national security, we work on the adaptation of the provisions. But even when those provisions have little to do with national security, we keep working on the adaptation. In other contexts, there will be efforts to adapt those provisions too. Mr. Bill Tang. Ordinary citizens will get their peace of mind because back in 2019 there were protests. The average person just wants to go to work. There was social unrest, and they said something they would get beaten up back then. That was a huge trauma to the community. This legislation has come late, but better late than never. The consultation has started in earnest. The FTU fully supports the legislation. After we get this bill through, people can live and go about their lives happily, and then we will be in a good position to focus on the economy. A good law should be more than enforcement after something has gone wrong. We want to prevent things from going wrong so that bad actors don't do the bad deeds in the first place. I'm confident in our law enforcement agencies. But let's not forget, judicial officers also have a role to play. Foreign forces are trying to put pressure on our judicial officers. They claim they respect the rule of law, but these foreign forces also try to pressurize our judicial officers. What will the government do in response? Do we have anything in this consultation or the bill? When foreign forces target our judicial officers, are there measures to guard against that kind of threat? Who's going to take the question, please? Secretary for Justice. I draw members' attention to Chapter 9. 9.23 onwards. There is protection for those involved in protection or safeguarding of national security. That includes judicial officers. Here, it covers everyone involved in safeguarding national security. So this includes law enforcement and judicial officers. For everyone involved in safeguarding national security, we need to protect these people from harassment. That's why we have this recommendation to step up protection for these officers. Anything to add from Secretary for Security? Now, one comment on prevention. This law is about prevention. We need an effective law to cope with future challenges so that bad actors will think twice before trying to threaten us. Mr. Dominic Lee. In 2019, we saw riots. Most people will see the importance of safeguarding national security. We have the national security law, and we're now trying to have local legislation for Basic Law Article 23. We want to plug this loophole. There is widespread support for this work. We also need to allay the concerns of stakeholders so that they don't have to worry about inadvertent breaches. For this consultation, there's a part on disclosure of state secrets. I talked to people in the press. They have a worry. People in the media come across information and then they disseminate the information. So these people worry about inadvertently breaching the future national security legislation because of what they do. Just then the secretary said there would be exemptions when public interest is involved. So I hope the government can take this approach. If there are exceptions, indeed, can we have clarity on the circumstances, the context, or the bodies involved before the exceptions will be applied? I believe the member refers to paragraph 5.8 in the consultation document. That has to do with state secrets. This is about without lawful authority, and then likely to endanger national security. So those are two elements. You need both before something counts as state secret. So you come across a document, you first think whether you have the lawful authority to disclose the information. If a paper comes with a chop that says government secret, then the average person shouldn't disclose the information. Now, the second point, does a piece of information have to do with state secret? The weather information is fine, but defense deployment, on the other hand, obviously have to do with national security. So if you have a document, you can exercise common sense to tell whether you have the lawful authority to disclose it and whether such disclosure would jeopardize national security. Again, intention also matters. We need to prove mens rea. Paragraph 5.8 also says that there are different requirements. These requirements have to apply before something counts as state secret. Now, on concerns about inadvertent breaches and public interest, we note such comments. We can have a discussion about what major public interest is. People cannot just claim major public interest in a casual way. Mr. Chen Hock-Fong, the country is paramount before we can call a place a home. After 2019, we saw the Black Lives riots. People can see the urgency and the necessity of legislation to safeguard national security. As the officials have told us, the future law will target just a tiny fraction of people. Most people will not be caught by the law. The law looks complicated. So how do we promote the future legislation so that it becomes easy to follow even for the public? The provisions look turgid. People have a hard time following what the provisions mean. So how can we make the provisions easy to follow for the public? Apart from the Hong Kong public, the international community also matters. How do we promote our legislation to the world? As another member said, how do we promote our local legislation to the international community? There are acts endangering national security online, information spread through social media, for example. Have we talked to social media companies so that they get a sense of what our local legislation is about? I'll first give a brief response before Mr. Tang can tell us more. We're talking about legal provisions. There are complex matters. So we try to make the provisions accessible to the public. We need engagement. That's why we will have occasions where we can tell people about the provisions. we explain the provisions, and we also find out where people struggle to follow about the bill so that we can respond to the points of concern. Now, on explaining to the international community, we have economic and trade officers overseas. We work through these overseas ETOs in explaining the bill to the outside world. The Chief Executive, the Secretary for Security, and I, we also arrange an occasion to explain the work to consuls general, foreign business chambers, as well as local business groups. We will also think of ways to get this work right. Your time is up. Ms. Jovi Chan. The FTU supports legislation for Article 23. We have been explaining this to people online and offline too. There is solid legal basis for legislation. We will also rally people around and we will explain the legislation. We will explain the legislative intent to show our resolve to safeguard national security. In Macau, they have had their own national security law in place for a long time. The law there is working well and does not affect people's lives, so that Macau can focus on their economy. So we should get through this legislation as soon as we can to plug the loophole. In Western countries, they have their own national security laws. Paragraph 1.3 here refers to the UK's National Security Act. Chapter 6 and 7 also refer to overseas laws. So can the government tell us, for the two new offenses, can the government tell the public that our legislation is up to international standards? We're also up to standards that protect human rights and rights. 9.14, 9.15. Now, there are 13 people on the bounty list. Now, in the U.S., such cases would involve in the revocation of the passport. And I also want to find out more about harboring criminals. Are there problems with cracking down on such offenses? Can the government tell us more so the public gets a better sense of the legislation? In 2003, we can still recall what happened. Some lawmakers here were involved in the 2003 exercise. I was a student back then. I learned from TV back then about the failed legislative attempt. There was a saga back then. In 2019, we had the Color Revolution. Now I'm honored to be part of this legislative process this year. So I want to express my gratitude to the government officials. Who will take the question? Secretary for Security. 9.14. About suspects who absconded. This has happened. There are laws overseas about revoking passports for abscondees. This is a viable way. That's why we're recommending this approach. Now, on those aiding abscondees, that's covered under other offenses, so we can deal with that under those provisions. Ms. Carmen Khan. We must legislate for Article 23. We need to move fast and we need an effective law. That's why after the Q&A session last week, I released a post saying that we need to put up this safety security barrier so that we can move ahead. I have some questions about the law. 1.4 and 1.5 paragraphs in the consultation document. Now there is a holistic approach to national security. This is from our country. Now, there's a new approach, holistic view of national security. That is, we adopt the definition in national laws. In 2003, Macau adopted the same approach. I welcome the fact that we are adopting this approach too. So will we turn to the central government for guidance? Article 17 of the Basic Law says that if Hong Kong's local laws are inconsistent with the central government's policies or prerogatives, the laws can be returned to Hong Kong. If we can have everything at one place, the public will have an easier time following the provisions. The existing laws are incomplete on national security. But now these provisions are scattered across different ordinances. Will we revoke or treat as revoked certain provisions under existing ordinances that are inconsistent with our future local legislation? National laws override local laws. So what happens when some local laws are inconsistent with national laws? Now, there are different institutions such as the Committee for Safeguarding National Security under the National Security Law. There are dedicated departments at the police force and the DOJ for national security. Will these institutions play a role in this legislative exercise? Secretary for Justice. The Basic Law Article 23 says that we should legislate on our own for national security. National security belongs to the CPG's affairs, so we need the agreement from the CPG as we proceed. Now, on inconsistencies between common law, local legislation, and the future legislation, this is a chance for us to consolidate provisions. Some provisions will be replaced. Now, on the institutions under the NSL, those dedicated teams are playing their role under the NSL. Mr. Sunny Tan. Now, most people, everyone in Hong Kong, loves Hong Kong and our country. Given that's the case, I fail to see how there can be objection to having legislation to safeguard national security. In 2019, we had the Black Clad riot. And then 2020, we had the national security law. Because of that, we now have sustained stability. Some argue there are economic problems caused by the national security law. But the fact is that this Office for Attracting Strategic Enterprises have brought in strategic firms. We also have many mega events. More will come. Multinational businesses can see our national security law is protecting Hong Kong and our country. So for this local legislation, we're improving our legal system. So how can the government better engage with local businesses and our overseas partners so that they understand that we keep improving our legal system so that we will see continued prosperity and stability?
Does any official wish to respond? Because there's actually expression of views. Secretary for Justice. Now, I think for anyone in business or the business sector as a whole, they want a stable environment for them to engage in any activities. So that's why we need to improve upon the whole legislation for national security, and then we can provide a stable environment. And as explained, we are going to organize various briefing sessions and seminars, and we will in particular talk to the business sector so we can address their concerns, and then we will convince them if we legislate for Article 23, that definitely is going to facilitate their business activities. Dr. Kennedy Wong. Now, I represent the Commerce and the Business and Professionals Division of the DAB. I want to express my full support for the legislative exercise and the public consultation exercise at this point in time. Now, just at the beginning, I heard some figures. That is, since the national security law was promulgated on the 1st in 2020, about 290 people were arrested, 60% were prosecuted. In other words, less than 180 people were prosecuted. So it's been about 3.5 years since the promulgation of the national security law, and we see that only a handful of people were targeted. The national security is called another name often. It's the stabilizing force for Hong Kong. So with it as the stabilizing force, at the same time, Hong Kong, we need to strengthen our own protection. Now, I represent the business sector, and my electors want most stability in Hong Kong, because we all remember well the Black Clad riots in 2019. There were rioters everywhere. It was like a lawless place. And then, of course, there are some examples overseas, and I hope the officials will consider it. Now, in the mainland, there are also laws to safeguard national security. So what is the difference between their laws and the one in Hong Kong? So we need to explain that to people. Now, the mainland has the highest FDI compared to any other places in the world. So they have attracted the most foreign investors. And then if in the public consultation document, there's mention of other countries and regions and what their practices are like, and I think the fact speaks for themselves. So we could explain that more to the people, and people will see that this legislation is going to benefit everyone here in Hong Kong. So I'm just stating my view. Next, Mrs. Regina Ip. Again, Chairman, did you say? Anyway, thank you, Mr. Chairman. I would like to thank the administration for putting forward this proposal. It's really comprehensive and precise. It's made reference to overseas practices. Now, my question is about state secret. Is it the case that in future all prosecutions will be the same as that for national security legislation law? That is, there is need for approval from you before prosecution can be taken up, because there is this stringent requirement now under the national security law. Yes, that's the case. The national security law has provisions that for cases involving national security, there is need for the Secretary for Justice to sign a certificate before prosecution can be taken out. And so going by the relevant provisions in the national security law, there will be such a requirement, because that's a very stringent prosecution procedure, to make sure that prosecution is not taken out lightly. And then I see for the Chinese term state secret will follow that of the mainland of the country. But then there are various levels of state secrets, and for some state secrets there may be time limits. Say after 20, 30 years, a secret may no longer be considered a state secret. So will we have the same arrangement? Will it, Secretary for Security? Well, there are certain documents within the government. After a certain period and after assessment, we will decide whether to lower the classification of a document. Now, I explained earlier as to whether a document is considered a secret is, first of all, we consider whether this is an open document. If it's the case, then of course that means there will be no unauthorized disclosure. So the first element will not be present, and that's why it will not be regarded as state secret. Well, two media friends often ask me the question now, Hong Kong is an international financial center. Free flow of information is important. If the media reports certain news, well, in the UK, they've now accepted public interest defense. So will we have something similar? Because the disclosure is based on public interest. Could that be used as the defense in our case? Secretary, yes, we've heard suggestion as to whether for public interest there could be a defense. Yes, we've heard your view, and we will actively look into that. And as I said, we talk about major public interest, and then we'll see how we can deal with that in the law. Thank you. Ms. Eunice Yung, I'm fully in support of the legislating for Article 23. I commend the administration for its approach, because the chief executive spent about an hour to explain the law, and he was able to explain the entire legislation to the people, including the legislative intent and what's going to be updated and what will be new and so on. So I commend that effort, because it makes it easy for the public to understand what's the legislation is about. Even the public consultation document is easy to follow. I just spent half an hour. I'm able to pick out the main points. Now, there will be some new offense. An offense about treason, and so it's about letting the public know whether an offense is grave or not, and then that is that people know they shouldn't support certain acts, and that's important for the public. And this is the misprision of treason. So for misprision of treason, and also in Chapter 9 about improving the whole system, and also about the question of suspects absconding overseas. We know that 13 persons are now on the wanted list. So for the new legislation, how can we prevent people from absconding? For example, could their passports be taken away? This is very important, because we want the public to see that they shouldn't give support to such people. They shouldn't give them monetary support. They shouldn't help them to hide, for instance. Now, they say for those who've already committed an offense, and then, or maybe after the enactment of the new law, how are such acts to be regulated? I don't know if the law will be retrospective, but how do we let the public know that they really should not support these people, continuing to do broadcasting overseas, or receiving money from people and so on? So how can we make sure that the new legislation could be implemented effectively? I'll first talk about the broad principles, and then Secretary for Security could supplement. Now, with any piece of law, an important principle is that the law must not be retrospective. Even for the national security law, it's stated clearly that there is no retrospective effect. So when we legislate for Article 23, we are regulating conduct after the enactment of the law. But of course, it doesn't mean that we won't touch on issues you mentioned. Perhaps the Secretary could explain that for people who give assistance to others to abscond, in itself, it will be an offense. Now, yes, if you assist someone to abscond, under the current legislation already, it is a criminal offense. Mr. Dennis Leung, thank you. I just want to share with you my excitement today. It's like, giving labor. Finally, we're seeing the legislating exercise for Article 23. We've been asking for it for so long. Finally, it's coming here. It's like when someone is in the Hong Kong is like Hong Kong is in the ICU. We need this special medication to cure us. and that's Article 23 legislation. Now, the Chief Executive and the Secretary for Justice and Secretary for Security explained the whole legislative approach or proposal to us this morning, and it's really comprehensive. So it covers most cases involving national security. But I hope when the administration explains the proposal to people, they shouldn't just limit themselves to the public consultation document. They should explain the content of basic law and relevant laws too, so people know exactly what the essence of Article 23 is. Otherwise, it's hard for people to see the rationale and the necessity for this legislation. In particular, I hope the government will go more to schools to explain the legislation to young people, because they are future. And if they can understand the whole legislative exercise, then it will be important for them to become a part of that effort in future. So we need to explain the legislation to both students and parents. Now, in 2019, when we had the Black Clad riots, the salary grade class really suffered. They could hardly earn a living. And now the legislation will ensure we have a stable and safe environment for businesses to be conducted. And here there's also the inclusion of espionage. In the past, you've been trying to explain that in plain language. I hope you will continue to do so people will easily follow what the legislation is all about. And as you try to promote and explain the Article 23, please do more such gestures, victory and okay. And I think that helps with your publicity effort. Thank you.
多謝主席。
So that's a comment from Mr. Low. Now we come to Ms. Elizabeth Quat. I fully support legislation for Article 23. When I heard the news, I looked at the consultation document. This approach is highly targeted. If we had this legislation back then, if the bill had been passed, then we wouldn't have the Black Clad riots in 2019. Someone was torched in 2019. Another one was killed by a brick thrown at them. There were police officers who were burned. There was a tourist who was beaten up badly with disabilities. None of that would happen had we got the legislation through back in 2003. So 2019 caused great harm to people. I lament what happened, but I'm also moved to see that we've come to where we are. Chapter 3, Treason. There's a ban on receiving training from outside forces. If we had this legislation back then we wouldn't see so many young people being exploited by foreign forces. Chapter 4, Incitement. Incitement of hatred was something common back in 2019. Chapter 5, the use of electronic systems to endanger national security or spreading false and misleading information to endanger national security. Again, that's a problem that crops up every day. Chapter 6, Sabotage endangering national security. That covers damaging public infrastructure and other offenses. Chapter 7, Foreign interference or external interference, preventing fugitives from absconding and protecting law enforcement officers from harassment. These are the points we have been calling for over years. The provisions target just a tiny fraction of people who endanger national security. For the vast majority of people, the law will protect them. For Hong Kong's continued prosperity, we need local legislation for Article 23 to ensure our safety and prosperity. I fully support this legislation. I hope the government can get the publicity and explanation right. If anything is needed from LegCo members in terms of support and assistance, we'll be happy to give our support. Thank you. That's Ms. Kwok's comment. Mr. Ma Fong Kwok. Thank you. Last week, we had the Chief Executive's Q&A session. I brought up this point. 20 years ago, I was at the Bills Committee in 2003, and I'm the only one still serving in LegCo here. I gave my full support back then, but that dragged on for 21 years. In 2020, the national security law was promulgated that addressed the urgent and pressing needs, but that wasn't all that was needed. Now this government has promptly started the legislative exercise. I fully support this. We need to get the consultation right. The consultation and legislation need to be detailed. 1 month is enough for consultation. After all, the concept has been in the works for a long time for local legislation for Article 23. Chapter 8 in the consultation document says that we need to be in line with international practice and standards in our legislation. We also need to achieve deterrence in the future law. So how do we achieve those goals? There are people who breached our national security legislation. How do we penalize those culprits? The document says that we need to carefully consider the security risks and come up with a proportionate response in the bill. So what specific measure will there be to target these security risks? How can we have such necessary and proportionate response in the bill? Secretary. So this is about the applicable scope. We normally regulate what happens in Hong Kong with our existing laws, but our national security law states that given the severity of some offenses, even offenses that were committed outside Hong Kong will still be caught by the NSL. An offense may have occurred outside Hong Kong, and even the culprit is not a Chinese national, but the offense is so severe that it endangers our national security. We also cover that under the NSL. When we have provisions with extraterritorial effect, the operation gets complicated. So we have to consider the circumstances in deciding whether we need to adjust the measures to keep the measures proportionate. Articles 36 to 38 of the NSL set out the principles about this issue. Mr. Peter Shiu. Thank you, Chairman. In 2003, we failed to get through local legislation for Article 23. A business partner talked to me some years later. We discussed this point. This business partner said we had nothing to worry about security in Hong Kong, and local legislation for Article 23 would have no impact on this partner. So this business partner had no strong views about Article 23. But then 2019 came. We went through what happened. The national security risks were there. The same business partner then told me they really regretted the failed attempt in 2003 because they could not run the business in 2019, given what happened. Fortunately, in 2020, our country enacted the national security law, and that brought back stability to Hong Kong. So now we need to put in the last piece of the puzzle. So the Liberal Party fully supports the government in promptly legislating for Article 23. Back in 2003, there were different people using alarmist tactics. There were people engaging in scaremongering, saying that business people would be arrested or speech would be criminalized. But let's look at what happened over the past few years. How many in the business circle have been arrested under the NSL? As long as you do not seek to endanger our national security, you can keep doing business in Hong Kong. Both the SJ and the S4S have told us about the overseas experience, and they will set up a rebuttal team. I was with Mr. Sunny Au at the last term government. We worked together in rebutting the fake news. So if government officials need our help as lawmakers or from the business sectors, we will help, and we fully support the exercise. Once again, the Liberal Party fully supports legislation for Article 23. So that's Mr. Shields' comment. Last one, reference Peter Kun. Thank you. Most people support this legislation. But there is one concern. People worry about being misled by people with ulterior motives, and then they breach the law inadvertently. I'm not looking for a guarantee. I'm just saying, where possible, can we have some form of reminders? Someone may inadvertently come into contact with a spy. So here a reminder would help. In this case, this is one way to put people's minds at ease. People may have a limited idea of what the law is. I explain to those people it's not like penalty ticket. National security is not like what you have with traffic offenses. Secretary for Justice. This morning, the Chief Executive brought up a key concept. In a criminal offense, we look at the criminal act and also the criminal intent. The law will target those who knowingly breach the law. So when someone unknowingly comes into contact with a spy, that person does not fall foul of a criminal offense. So we look at deliberate act. That's what constitutes a criminal offense. So people shouldn't have to worry about accidental, unwitting breaches of the national security legislation. And that goes for other criminal offenses in general. Members, we don't have time for all remaining 7 members to speak, but there are other chances for members to discuss legislation on this topic. 21 members have spoken. They are from different parties. Some are without party affiliation. All members spoke in favor of the legislation. They have made comments on legislative principles and the consultation. Can I ask the government officials and try to take on board members' comments? We will conclude the meeting here. Thank you.